Ebusha for me ma obi biara a happy new year. Ya senya kopon se onko so a emfa na basa kese na emodu no ensa to ye so afe a 2025 no sama ye ni ehu 31st December 2025 ni ensi afofofo 2026. So right now no nyenko kopiem e Supreme Court. Ye to aba ni wie ye no na you know, you declare say already, no. A former President John Dramani Mahama or no, and I say now, you know, most of the seats Ghana has say first 16 regions now. Former President John Dramani Mahama, Yebeka Otimina, Ebia 10%, and Dr. Mahmoud Al-Haji Bawumia, and so in 5, no. But anyways, no. Now you share that in you know, some of the constituencies or more votes, no, and by Mekainsa because a nagidi be NDC for youth, no, and our supporters, no, a giddy be a mantamo. Vasisiano, a beer bar Bekainsa. Now Bekainsa, no, and no, and an NDC for a patcher say, or Montias, say, a beer to Quasi, no, right now, no. Omo bobo no ama results na beka yensa no MPP for na afasa city no itomu de kopie mu we Supreme Court na ekopie mu we Supreme Court na abusuafo asresem ne se aye judge otina kunwem se eye nokre se eye MPP ni and say MPP you know make can say candidate a woginaye na afa seat no especially Dome Kwamenya or no Safoa address Safoa and anana a member of parliament, but due to you know some reasons and you know Sembia neko koso akodi agoche musembe breno ebusa for resha for a cano maniko penny baby tonight but sisiano I want some ne say dear Nadam still na NDC for someone to say in fact most of the constituencies are na results in MBK interpret Beka MPP for afano NDC for someone to say no akakopie mu Supreme Court amayetiantia NDC for lawyers so omo komano ntum na aba no de tia enetie omo kra say omo sure so mbaba ye minority parliament na MPP ababa ye majority parliament but for it seems that baby akika kono but enyehu yenchen na de bebebia yensa fambro come on na chesi yenkoti mu nsem emrasisia medase
those positions should not be recorded.
Well, no, we said that the man stated that he gives information. If you think that it doesn't actually establish the fact, that is a different matter.
Yes, the court to consider. My lord is a registrar. The registrar. Now, if the applicant does not file a single case within a time stipulated under Article 2, the registrar shall certify that fact to the court, which may dismiss the application for non-prosecution or make such other order as it may consider appropriate. There is nowhere, my lord, that the non-filing, the statement of case, deprive the court of jurisdiction to detain the application that was before it, to the extent that the registrar or the court, which was supposed, if it was desired to do so, made no such order. In any event, my lord, the respondent, that is the EC, that was supposed to go and carry on did not put application. They took the view that yes, they wanted to go and do their work. And indeed, my lords, they have gone to do their work, declare the winner, declare the loser, and the matter is so close. Oh, so close.
If that were the law, the illegality will persist forever.
My lords,
so I'd like your other arguments, but As for foreclose, your other arguments you have answered substantive.
My lord, an order by a court to proceed to perform a constitutional essential function.
If it's set aside, that would be the consequences are clear in the authorities. Anyway,
with respect.
Yeah. Your other points I will take, but as for this one.
Yes.
Yeah.
Further, my lords, it is not the applicants that were going to perform the said constitutional duty. Not the applicants. It's the first interested party. So granted, which I already indicated that the joint application was not funded by the rules. Granted, they will not have been a necessary party to the action. Granted, because the application was directed at a specific body, the EC, and no one else.
Now let me pick your mind on something the trial judge said in the ruling by Nana Equia Owusu Afriye. If one of your assistants can open to that. The ruling in respect of the application by Nana Equia Owusu. Yeah, be serious. Now, if you can read the whole of paragraph 1 and it extends to the next page, read it and...
Paragraph 1.
Yes.
As we be serious, the application on the face of it is not different, in the person of Godwin Edugi Kujo Tamaklu, to the effect that the winner of this constituency has been declared, and which has no evidence for this court, except an application yet to be moved. It is observation of this court that the respondent will not be affected if indeed it has been declared already.
Now you stop.
As it stands.
No, just now you stop there. You see, this conditional, if it has been declared already, where does it leave us? Because the applicants are contending that it was declared already. And then she's saying that if it has been declared already, then this ruling doesn't change. I'm finding it difficult.
Alas.
Yeah, you were there, so probably you...
Yes, alas. The application, my friend, far before you. If you look at all the exhibits which they have filed, my lord should realize, what is all this? My lord should realize that they have not, or they did not, what is this? They did not, no, our application. Yes, they did not attach any parliamentary election results summary sheet to demonstrate that, in fact and indeed.
Oh, we hadn't reached that stage.
Direct me
properly. No, the point I'm making is that the judge is saying that if there had been a declaration already, then the person whom it was first declared for would not be affected by this ruling. But that is a very risky, slippery ground.
The bottom line is that, let's say, even there was even a declaration, in quote, but there was none, in quote. If the collation is done and you won, it will be confirmed that indeed you have won.
No. The judge said it will not affect her. Anyway, it is not your writing. It's because you were there, that's why I wanted you to react.
There is no way that if you win an election, and you have won an election, the results will change. If you have won, you have won. If you have lost, you have lost.
Anyway, that is the dispute. The dispute is whether the first person won or the second person. So that's the dispute. But I must be honest with you that the application before us, we are not in a position to resolve the factual dispute.
That is so.
As to whether the person who was first declared or the person who was second declared. We are not in a position to resolve that dispute. Ours is to look at the legality of the proceedings that resulted in the order for the Electoral Commission.
Yes.
Yeah, so wind up and then...
So, my lords, in conclusion, I submit that another High Court judge was acting within a jurisdiction there is no error of law patent on the face of the record. Which errors goes into jurisdiction, which is so plain to manifest a nullity. There was no breach of natural justice. So, my lords, we submit forcefully that the High Court judge exercise a discretion.
10 days, 1,000. My
agreed about the discretion so exercised by any High Court judge. Their remedy